There's been a quiet earthquake in the way gun laws are written, interpreted, and enforced in this country, and I'm betting most folks didn't see it coming. It wasn't splashed across every news feed, but make no mistake, it completely reshapes the battlefield for anyone who owns firearms. This change didn't happen overnight. It's been building in the background for decades, unnoticed by most people. But if you've been paying attention to how the Bureau of Alcohol, Tobacco, Firearms, and Explosives has been slowly stretching its authority, inventing rules out of thin air, and enforcing restrictions Congress never actually voted into law, then you're going to want to listen closely. The ground just shifted, and not in a small way. This is the kind of legal aftershock that touches every single gun owner in America, even if you've never dealt with the ATF directly. The old rulebook, Chevron deference. For decades, the ATF operated under a legal shield called the Chevron Doctrine, born out of a 1984 Supreme Court case. Chevron USA, Incorporated v. Natural Resources Defense Council. Incorporated, in plain English. That ruling said if a federal statute was vague or open to interpretation, government agencies could decide what it meant, so long as their explanation wasn't totally absurd. The logic was that these agencies had specialized expertise to fill in the blanks. But that opened the door for massive overreach. The ATF began stretching firearm laws well beyond what Congress ever envisioned. Look at the National Firearms Act or the Gun Control Act. Both were written long before things like pistol, stabilizing braces, three-dimensional printed lowers, or forced reset triggers even existed. The ATF's mindset became, if Congress had known about these, they would have regulated them, and with that, they'd roll out a brand new rule. No vote, no new law, just an agency decree. Overnight, something completely legal yesterday could become a felony today, purely because the ATF decided it was so. This created a strange parallel reality, where the text of the law said one thing, but the ATF acted as if it said something entirely different, and most people never caught on. The game changer, Loper Bright, Enterprises v. Raimondo. That all flipped in June of 2024, when the Supreme Court handed down its decision in Loper Bright Enterprises versus Raimondo. In that ruling, the justices tossed Chevron into the dumpster. They made it crystal clear, unelected bureaucrats don't get the final word on what laws mean judges do. For the ATF, that's a game changer. Now, when they say, this device makes your gun a machine gun, a judge can respond with, point me to the part of the law that says that. If it's not written in the statute, their opinion carries no automatic authority. And it's not just the ATF, this applies to every federal agency, from the Environmental Protection Agency to the Food and Drug Administration. But for those of us who've been watching the ATF's creative definitions, this is monumental. It throws open the door to challenge a long list of rules that leaned heavily on Chevron, things like so-called ghost gun restrictions, the 80% lower crackdowns, bump stock bans, and forced reset trigger classifications. Some courts, especially down south, are already revisiting these cases with fresh eyes. The new reality. The balance of power has shifted hard. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives could unilaterally decide what was legal and what wasn't, and gun owners were expected to simply comply. That era is over. Now they have to make their case in an actual courtroom, in front of real judges, and defend their positions against the plain language of what Congress actually wrote. This new legal landscape means that people who were branded criminals for owning something as simple as a pistol brace might finally have their day in court. We're already seeing judges strike down ATF rules, and that trend is gaining momentum. The old play of, because the ATF says so, is gone. Now the courts are saying, show us where Congress put that in writing. Even older regulations are suddenly on shaky ground. Before, if a rule felt wrong but came from an agency, courts would usually shrug and say, we have to defer to them. That's history. Judges can now throw out any regulation that doesn't match the letter of the law. That means past bans, enforcement policies, and agency definitions are all open to being challenged. If Congress didn't pass it, it's vulnerable. Now, don't think the ATF's been declawed. They still have the power to propose new rules and issue guidance. The difference is, they can't count on blind deference anymore. If they cross the line, the courts will smack them down. Expect to see tighter, lawyer-proof language in future regulations, and possibly even attempts to push Congress into rewriting the National Firearms Act or the Gun Control Act. Politically, that's going to be a steep climb with the nation this divided. But you can bet they'll ramp up the public relations machine after any high-profile shooting, aiming to build support for more restrictions. The road ahead. The Supreme Court's recent ruling is a big step forward, but let's be clear, the fight is nowhere near finished. All this decision really does is shift the battlefield. Now, the ball is back in Congress's court, exactly where it belongs. If lawmakers want to pass a new gun restriction, it should be done in the open, public debate, roll call votes, and full transparency. No more slipping rules through the back door with an agency memo. That's why supporting the groups holding the line, like the Firearms Policy Coalition and Gun Owners of America, is so critical. These are the folks bringing the lawsuits, calling out overreach, and forcing the Bureau of Alcohol, Tobacco, Firearms, and Explosives to follow the law to the letter. We've already seen those efforts pay off with real wins. But those victories only happen when there's steady pressure in courtrooms, in Congress, and in the court of public opinion. Yes, we should celebrate this ruling, but we can't let our guard down. The ATF hasn't shut its doors. They're still drafting rules, still pushing boundaries, and still backed by politicians eager to tighten gun laws. The difference now is that the curtain's been pulled back. They can't hide behind vague interpretations anymore. That cover is gone, and that gives us room to push back harder. Here's the reality. Just because the ATF took a loss in court doesn't mean they're suddenly playing nice. Their history says otherwise. 1-year pistol, stabilizing braces are fine. The next they're banned. Then they're conditionally allowed, and before long, they're reclassified as short-barreled rifles. This constant flip-flopping isn't clumsy, it's calculated. By keeping gun owners guessing, they've scared people into compliance, making folks ditch perfectly legal equipment just to stay out of trouble. That tactic has worked for decades. But now the courts have spoken with a louder, clearer voice, and that changes everything. Rulings based on the old Chevron deference, now dismantled, are wide open for challenge. Gun owners, who were boxed into no-win situations, losing property or facing charges based solely on an agency's shifting opinion, now have a real shot at justice. Congress writes the laws, agencies interpret them. The court just reminded everyone there's a hard line between the two. One of the best signs, how quickly lower courts reacted after the Supreme Court ruling. It's like they'd been waiting for the green light to stop rubber stamping whatever the agency claimed. Now they can read the statute, weigh the facts, and make their own decisions the way the judiciary is supposed to work. Still, the fight isn't over. The same people driving the ATF's aggressive rulemaking are still in place. They'll repackage the same restrictions with new wording, hoping something slips through. Some of those will survive unless they're directly challenged, which is why awareness and legal action remain essential. We've entered a new chapter, and each court win now has the power to send shockwaves across the country. And let's not forget the weight of public pressure. Calling your representatives, backing pro-Second Amendment legal teams, keeping your shooting buddies informed it all matters. These agencies depend on the public being too busy or too intimidated to push back. But when the firearms community stays engaged and united, it's a lot harder for overreach to sneak past. I know it's exhausting. There's always another proposal, another ban, another regulation. But if you've ever wondered whether fighting back makes a difference, just look at what happened. A decades-old legal shield that let agencies act like lawmakers is gone. That's not luck. That's the result of people showing up, lawyers fighting hard, and judges listening. So yes, this is one of the best legal developments gun owners have had in years. It doesn't mean we've won the war, and it doesn't mean the ATF won't try again. But it does mean we finally have the footing to go on offense instead of just playing defense. That's where we stand. I'd like to hear your take. Is this a real turning point? Do you feel hopeful about what comes next? Or are you still wary of the ATF's next move? Drop a comment below. If you found this breakdown useful, hit that subscribe button. I'll keep tracking every change and walking you through it. Until next time, stay sharp, stay safe, and keep the line strong.